and welcome to Prime Debate. The role and responsibilities of the judiciary in India is a subject which has been under constant scrutiny. The debate broadly centers around their powers vis-a-vis the legislature and the executive and its accountability. These issues have once again been brought into the center stage by none other than the Chief Justice of India, Justice S.H. Kapadia, who cautioned his fellow judges against overreach. Coming from within the judiciary, this is a pleasant surprise.
It looks like an honest self-introspection by an important pillar of the Indian democracy, the judiciary. Chief Justice of India, Justice S.H. Kapadia's recent observations while speaking on jurisprudence of constitutional structure at New Delhi have set off a debate on the role of the judiciary in our democracy. Justice Kapadia has said that judges should not govern this country because they are not accountable to the people. We need to go by the strict principle, whenever we lay down a law, it should not interfere with governance. We are not accountable to people. Objectivity and certainty enshrined in the basic principles of the Constitution have to be given weightage, Justice Kapadia has said. He has also said that while delivering verdicts, the judges should apply the enforceability test to see if it would be possible for the executive to implement their directions. He also wondered what would happen if the executive refused to comply with the directives of the courts. With these assertions, Justice Kapadia has called for a fair balance of power between different organs of the state, the executive, the legislature and the judiciary. Implicit in Justice Kapadia's observations is the need for restraint and a wise retreat to the space that he thinks legitimately belongs to the judiciary. But can these observations be interpreted to mean that judiciary should no longer be proactive and resort to judicial activism? If the answer is yes, then what will happen if the executive and the legislature fail the citizens in fulfilling their fundamental obligations? Will the judiciary watch helplessly, or will it intervene so that the rights of the citizens are protected? And how much judicial intervention is just intervention?
What do other judges and legal luminaries feel on the issues flagged by the Chief Justice of India? To discuss this, I am joined in the studios by a very prestigious panel of Dipinder Singh Patwalia, an advocate of the Punjab and Haryana High Court and the Supreme Court, Justice R.S. Mongia, former Chief Justice of the Guwahati High Court, Justice J.C. Verma, former Judge of the Rajasthan High Court, and Justice K.S. Garewal, former Judge of the Punjab and Haryana High Court. Welcome to the discussion. Mr. Patwalia, I'll start with you. First, a quick reaction on what Justice Kapadia has said, that the judges should not govern, they should not interfere in the governance.
My personal opinion is that what he said would not be an opinion of the judiciary as a whole. It certainly is his own opinion. Judicial activism, according to me, is a misnomer. What the courts are exercising today is the power of judicial review. There is no activism, there is no overreach. In fact, our constitution, written in nature, gives us some fundamental rights. Along with that, they also direct the state to act upon some directive principles. It is where the legislature and the executive are failing to protect those rights that the judiciary steps in. And according to me, there is no activism at all. It is only a review of the situation which is present.
But what do you think made the Chief Justice of India make these observations?
Well, I can't say these are his personal views, and he is certainly entitled to the same.
Justice Mongia, what is your view? What is in fact your first reaction to Justice Kapadia?
I will agree with Chief Justice of India that our constitution provides a mechanism, that is, there are lines drawn, judiciary, executive and legislature. None of these three should impinge on the jurisdiction of one or the other. Now, if judiciary, what I think he meant was, if judiciary starts governing, governing is not the part or the duty assigned in the constitution to the judiciary. Judiciary's job is to interpret the law which the legislature makes.
But Justice Mongia, the very fact that the Chief Justice of India should have made such an observation, does it mean that the judiciary is indulging in what we can say an overreach?
Must be. I give one or two examples. Okay. Now, even the Supreme Court itself, let me.
Okay.
For the appointment of the judges of the High Court and the judges of the Supreme Court, the Constitution says Chief Justice of the State High Court shall recommend a name. Word is Chief Justice.
Right.
and then the Chief Justice of India will consider that and then pass on to the Prime Minister's office, this, that, and other. What is Chief Justice? Now you may call it judicial activism, or by adding words in the Constitution, or by amending the Constitution. By way of interpretation, I must say, the Supreme Court said Chief Justice would mean Chief Justice plus 2 judges, what they now call collegium.
Right.
It started like that. President of India sent back the one case for certain clarifications or opinion of the Supreme Court arising out of the first judgment. The questions were framed. There was no question at that stage whether the collegium is all right or not. While giving that opinion on the questions framed by the President of India, Supreme Court said, in the Supreme Court the collegium shall consist of 1 plus 4 judges. I fail to understand that. You may call it judicial activism, you may call legislation by the Supreme Court itself. I give another example.
Justice Mongia, this case apart, what if the executive stops functioning or does not, is blatantly unfair?
Exactly, I was coming to that.
Right.
If now the legislature job is to legislate, executive job is to really implement and see that everything is implemented as per the wishes of the legislature. Correct. Now supposing the legislature does not legislate a law on a point which the Supreme Court or the High Court thinks they should legislate. I'll give you just an example also. While I was heading Punjab State Consumer Dispute Redressal Commission, lots of cases in the High Court are coming where it was being said by the insurance company, this license is fake. That point was coming. Or, sir, my original license may be or may not be fake, but my renewal of that from another state is valid. These were the points coming before us. There, while writing a judgment, I had said, because we can as only recommend or make a suggestion to the Parliament that time has come where you should amend the Motor Vehicles Act to include this.
Okay.
I've just include this, that instead of insuring the motor vehicle, insure the person who is to drive, like in England, like in USA, there the persons are insured. Now, while insuring the person, it will be duty of the insurance company to see whether he has a valid driving license at that stage, and lot of litigation will not be there. Similarly, I said, why can't we have an electronic system where if I have to engage a driver, I'll just press, all right, he says, I've got this license from Calcutta. I go to Calcutta and see whether this...
Justice Mongia, indirectly you did go beyond your functions.
No. That's what I'm coming to. No. I said we can suggest to the legislature that these are the shortcomings. Please legislate on that. It is high time to show.
I'll just come back to you.
Just one, give me one. Just coming to that. Now, despite that suggestion going to the legislature, we sent the copies to the concerned authorities in the legislature. Now, supposing they do not do it once, twice, thrice, should the judiciary just sit with a folded hand? What can we do, bhai? Ye to chalta hai. If that stage has come, even after suggesting on a particular thing that you should do A, B, C, and they have not done it, perhaps it will be all right for the judiciary to interpret the law in such a manner, as I suggested the Supreme Court did in collegium case, or for that matter, judicial officers' age. They said it should be 60. Though it is the function of the state to make rules.
Yeah, Justice Mongia, I think you raised a couple of issues. I'll just come back to you. Justice Verma, first a quick comment on what your opinion on Justice Kapadia's observations is.
I totally agree with Justice Kapadia's observation on this. Okay, yes, number one, that the judiciary should not try to govern. So far governing is concerned, that is the subject of the executive under the Parliament. And two, the judiciary should not formulate the laws. They can interpret the laws. If the law is defective, laws alter constitution, or it
but if the government or the executive is blatantly unfair,
no, I'm becoming,
what happens?
No, it's not a question of unfair. Suppose the executive is not working properly or the legislature is not working properly. This is the only thing you say. Then all right, then a judiciary of its own wisdom can say, no, here goes the executive and here goes the Parliament then. So far we have got the Parliament, so far we have got the executive. If executive is not working, there should be some person going to the judiciary. My this right has been violated, executive is not working, or it is working wrongly. Or
does it not mean the same thing? The judiciary in that case is then trying to go beyond its typical constitutional function?
It will not be. Then it will be interpreting the rights of that person, whose rights are being somehow not cared to by the executive or by the parliament. One thing is there, which a little bit I feel on this. How is it that every Supreme Court judge or Chief Justice of Supreme Court, at the verge of retirement, he gives all these things? Sometimes he says,
no, I think Justice Verma, it kind of shows their own functioning too. I think Justice Kapadia has, all along while he was or has been on the Supreme Court bench, I think he has desisted from what we can say judicial activism, though Mr. Kotwali doesn't agree with that word.
CJS Kapadia is not the Supreme Court. He never sits alone there.
Right.
Isn't it? So there is Supreme Court means Supreme Court. So for framing of a policy for the government is concerned, I think is none of the function of the judiciary.
Right. Justice Gariwal, what is your opinion on what Justice Kapadia is saying?
I have had the advantage of hearing all the three views.
Yeah, that's right.
And I think we have to strike a balance between judicial activism and telling government what to do and how to do it. So governance is the set of rules, practices and principles which come into play when the state interacts with the citizen. So if there is good governance, then the citizen's rights are protected. If there is bad governance, then citizen suffers. So courts can't do governance. That is difficult for the courts to do.
But courts can definitely intervene. We've had people like Justice Kuldeep Singh, who is actually referred to as the green judge. We've had judges like Justice Krishna Iyer, who went, perhaps beyond his brief, but intervened in cases of human rights violations.
That is not governance. That is judicial activism. They are two different things.
Okay.
So if we mix them up, then it gets very difficult to separate them. Governance is, you tell the DC, to protect the forests. Okay, he has to do it. But if you tell the DC, look, in the morning you'll go at 8 o'clock in the morning and go and inspect the forest, see if the forest guards are there and things like that, that becomes governance. I mean, that judges should not do. I mean, and what they do is, if the DC doesn't do it, then he's called to the court and
can you really draw the line between governance and the judicial activism?
Some of the high courts have been giving directions. Go, watch, check any person going with black ribbon on the cars or this and that. He should be immediately challaned or this and that. Otherwise, it is violative of the law under the Motor Vehicles Act. They can do it otherwise also. And the judge sitting at the churaha and doing it itself. So it is nothing.
Right. Justice Mongia, I remember this famous case of Ram and Shyam versus the state of Haryana on the allotment of mines. Now, in what category would that fall?